All right, well, I think we can start now. So, hi everyone. Welcome to today's call. So, today we have John from Weist Business Law. Did I pronounce it correctly, John?
It's Weist.
Oh, Weist, there you go. An experienced attorney who worked with many of our accelerators throughout their journey. So John is someone we trust and frequently refer to our AE. Frequently refer our AEs to. And as promised, usually after the call, I'll provide his contact details. So John, I'll hand it over to you. So the floor is yours.
Thank you so much, Andy. I'm going to share my screen, a PowerPoint presentation that I have. And I'm really excited to be here talking to Acquira folks, acquiring entrepreneurs. As Andy said, I've been working with Acquira folks for some time. I started working with Acquira last year, have done a number of deals with Acquira clients that I've been able to help them get their deals to close, and it's been a great experience. I think that you folks are well prepared when you're buying your business, and it's a pleasure to work with people who've come through Acquira. So my presentation is called 6 Key Questions when you're buying a business. I wanted to talk about what is the kind of lawyer's role in helping you as you're going through this process and of buying a business. And so, let's see, is it still working? Can you guys still see my screen, Andy? Yeah,
Yep,
you can.
working.
Okay, great. So just to start off, a little bit about me. So my name, as Andy said, is John Weist. I am an attorney. I'm based in Salt Lake City, Utah. I grew up in Salt Lake City. I've lived here most of my life, and I'm based here now. I've been in practice for 10 years. I graduated from Harvard Law School. I was in Utah, went to Harvard for law school, and then came back when I graduated 10 years ago to work at a large international law firm that had an office here in Salt Lake City. And I've been here ever since. I worked at a big law for the first 6 years of my career. And that was a great experience. I got a ton of practical experience, was able to learn from some very experienced attorneys. But it got to the point where I wanted to kind of do something on my own. And so almost 4 years ago, I split off and formed my own practice, which is now Weist Business Law. And I focus on mergers and acquisitions for small and mid-sized companies. And so I have, throughout my career, done dozens of M&A deals in many different industries, in many different situations. Some of them were in distressed situations where one company was going out of business or something like that. Now it's much more, kind of regular deals like Acquira is helping you folks prepare for. And I've represented sellers, I've represented buyers, I've represented lenders, and have a pretty good feel for how these kinds of deals go. Most of the deals that I do are between $1 and $10 million. That's a good size for a solo practitioner like myself. Sometimes I do deals under $1 million. It just kind of depends. And I really enjoy what I do. There was a point in my career where I was a litigator, which was kind of fun, I think, when I was younger and hungrier, but then I got tired of fighting with people all the time. And I really enjoy doing M&A deals now because my clients, whether they're buyers or sellers, are like pretty excited about what's happening. They're doing something that they want to do, and I get to help them kind of move that forward. And it's just nice to work with folks like that who are feeling good about the steps that they're taking and need a lawyer to help them. So really quickly, I just kind of wanted to go through the key stages of buying a business, and we're going to focus kind of in the middle of this list. And you probably all already know this and are somewhere, I think, in this process. The very first step is you're searching for a business that you and because of who my audience here, just to clarify, I'm focusing this presentation towards buyers. And I'm not going to talk so much about what I do when I represent sellers, but in representing buyers, this is typically what I do. So first is you are searching and you're looking for a business that you want to buy, something that fits the style or the lifestyle that you want, and kind of your dream of owning your own business. And you go through a pre-diligence process where you maybe work with a broker or acquirer is helping you, and you're figuring out, is this company worth what we're actually, is it worth what they are asking to pay for it, and is it a business that I actually want to run? When you get to the point where you find a company that you're interested in, then you send them a letter of intent, an LOI for short. And the LOI will lay out the basic terms of your agreement. You probably all are well aware of this, and some of you may have LOI submitted already. Acquira has like a kind of standard form template LOI, which I've seen in many of them, and it lays out the basic terms such as the purchase price. There's going to be seller financing of any kind, what you're going to be buying, et cetera, et cetera. There's a exclusivity period where you say, the seller and the buyer agree that you're going to do some due diligence while you're on the seller, and the seller's not going to shop their business to somebody else in the meantime. So hopefully in the LOI, you get kind of the basic terms of the deal set out. And once both parties have signed that LOI, then you're kind of off to the races and moving towards closing. And then three things happen simultaneously. One is you as the buyer are doing due diligence on the seller and the target company. You're looking at their financial statements. You're looking at the contracts that they have, checking into their corporate structure. And some of this you may have already done, but some of it you haven't had access to until an LOI was in place. And at the same time that you're doing that, you are also probably working to get your financing in order. You're probably, using a bank to finance the purchase. And so you're working with the bank to get towards a commitment letter, and everything else in place that they need to feel comfortable lending to you. And also, so these three things are due diligence, purchase agreement, and financing are all happening at the same time. So, and the part that I'm helping you with is the purchase agreement. So your LOI is going to say, hey, the parties, we're setting out in this LOI just the basic terms. The parties are going to work on a definitive agreement that sets out all of the terms of the deal. And that is the purchase agreement and its related documents. And my main job as your attorney, as the buyer's attorney, is to help you with the purchase agreement and related contracts and agreements that are either attached to the purchase agreement as exhibits or signed at the same time. And that's a process where I'll draft it up, I'll draft up the purchase agreement, I'll talk to you as the buyer about it, and to make sure that you understand everything that's in there. And then we will present it once you and I are comfortable with it. We will then present it to the seller and the seller's attorney. And we'll kind of go through, hopefully, not too many rounds of back and forth, negotiating the terms of the purchase agreement. Some of the terms should be, straight out of the LOI, and some of them may not have been talked about before, and so will need to be more heavily negotiated in the purchase agreement process. But once we have gone back and forth with the seller and the seller's attorney to get the purchase agreement into a final form, then most banks will require you to sign the purchase agreement in advance of closing. So you will not have a simultaneous sign and close. You'll typically, when you're working with a bank, you'll have the purchase agreement signed on a certain date, and then some period later, hopefully not more than a couple weeks, you will actually close on the business. But we need to get that purchase agreement kind of going back and forth between the parties relatively early in the process, because it hopefully won't take too long, but sometimes it can take a while. It just kind of depends on the situation. So once you've done your due diligence, drafted, have a purchase agreement in place, and jump through every hoop that the bank wants you to jump through to get a loan, then you will have your closing where you as the buyer the bank will lend you a bunch of money, you'll give it to the seller, and you'll kind of sign some more final documents, and then the seller is going to give you all of the things that you bought, whether it's the stock in a company or all of its assets. So that's kind of the basic stages of buying a business. Again, this is probably not news to any of you, but I'm going to talk mostly about the purchase agreement and the information that I'm going to want to know from you as the buyer, and going to want to talk to you about while we're getting the purchase agreement in place. Okay, so the question you may be wondering, well, when should I engage a lawyer? When's a good time? There are kind of two main options. You can either do it before the LOI or after the LOI. For most of the clients that I've gotten through Acquira, they already have an LOI in place. So that's just, you've had a business advisor that has been helping you with the LOI stage. So you haven't necessarily needed a lawyer up until you got your LOI signed. And that's great. I have a lot of clients who do come to me with an LOI already in place, and that's fine. I don't have strong feelings about whether that's good or bad. It usually is just great. Sometimes you may want to engage a lawyer before the LOI, just maybe it's a little bit trickier, or you're just like, hey, I just don't really know what I'm doing here. I want an attorney to help me draft up the LOI in the first place, and that's great as well. I'm happy to do that, and happy to kind of point out to somebody who doesn't have many other advisors, hey, these are the things that need to be in an LOI. This is what you need to talk to the seller about before you guys even agree to move forward on this journey together. So you can do it either way. I'm pretty agnostic as to when I come in, whether it's before or after the LOI. But if you do need to get an attorney pretty quickly after you sign their LOI, I believe. So then, kind of the mechanical process of how I get engaged is, we will hop on a call. I'll talk to you kind of about your deal. If you have an LOI, I will have it in front of me. We'll ask a couple of questions about it. And then if we, feel like we want to move forward together, I'll send you an engagement letter that lays out the scope of my services, says, this are the things that I'm going to do for you. These are the kind of contracts I'm going to draft for you and how I'm going to help you. And it will also probably have a section that says, hey, I'm not going to help you with these other things that may come up. I'm happy to help you. And then, if you want me to help you with these other kind of ancillary things that are not typical, but may come up, but they may be for a different rate or whatever. And then I typically require a retainer up front when I help clients in these situations. That's very typical for attorneys. And then once I have an engagement letter and a retainer in place, then I'm legally and ethically your attorney and happy we have an attorney-client relationship and can move forward together, and I'm happy to help. I also almost always recommend that my clients talk to financial and / tax advisors. Tax issues come up in these deals all the time. I know enough about tax to be dangerous. I'm not a tax expert, and I'm not a CPA. And I think it's very helpful for you as a buyer to have a financial expert in your corner that can be helping you with plan and get your deal moving in the right way for tax and financial reasons that I can't necessarily help you with in depth. So, okay, with all of that kind of background, let's hop into the 6 key questions that I'm going to ask you. And after I've engaged, or either in our very first call or after you've engaged me, and we're starting on the purchase agreement, I'm going to talk to you about these 6 questions. So the first question I'm going to ask, and we'll go through all these in detail, is this a stock or an asset purchase? That is the very first thing that I need to know, and that you as the buyer need to have clarity on very quickly. The second thing I'm going to ask, and this may seem kind of duh, but it is kind of nuanced, is who is the buyer, and then also who is the seller. Get more in detail on that in a second. I'm going to want to talk to you about the real property where the company operates and how you want to move forward in that space. And we're going to talk about financing. I'm going to say, how are you financing this deal? Let's talk about some of the details on that. And the very last question, last but not least, is what about net working capital? So this is by no means an exhaustive list of things that an attorney is going to want to know when they're helping you as a buyer, but these are the 6 kind of things that, in my experience, have come up the most and require the most back and forth with my client about. So very first one, stock versus asset purchase. And if you already know all this, I apologize if I'm preaching to the choir, but the first thing you need to figure out is, you have a target company, Acme company, let's say, and the question is, are you buying the company itself, also known as a stock purchase, or are you buying all of the company's assets, also known as an asset purchase? And so this is like dealing with legal entities and liability and kind of very lawyerly things. And so I like to use an analogy when I'm talking to my clients about to help them kind of wrap their heads around this. So I want to ask, let's say you have the target company is a store. Let's call it Acme Store, LLC or incorporated. Has a storefront, has a building, big sign on the front, says Acme Store. Everybody knows where it is. They know that's where they go to get whatever widget Acme Store sells. So my question for you is, are you buying that store itself, or are you going to build an identical store right next to it and buy all the stuff inside of the old store and move it into a new store? And so if you were going to buy the store itself, you're going to buy the building and everything in it, then that is a stock purchase. And I'm saying stock here, stock is specific to corporations. Corporations have shares of stock as their ownership, interest that people own. When they own a business that is a corporation, they own stock. If it's an LLC, the ownership interests in LLCs are called membership interests. They're not called stock. But I'm going to just use the word stock to refer to both for the sake of convenience throughout this presentation. So if you're going to buy that store, you're like, hey, I want the whole building. I want the sign up front. I want all the stuff inside of it. I want its reputation, everything. I'm buying the stock. I'm buying the company itself. And in that case, the owner, is a human being that's inside the company. They are inside of the store. They have the keys to the store. They come out and they walk out of the building. They hand you the keys to the store. You hand them a bunch of money and they walk away, and you walk in and you own that store and you own everything in it. So there's some pros to a stock purchase like this. One is it's very simple from a kind of a practical standpoint. It's turnkey. You walk in, store's already there, people know where it is, and you have the keys, everything's already in place. You don't have to move anything. You just walk in and you take over. So there's no need to transfer any assets. So imagine you're buying a corporation or an LLC. You're just taking it over. You don't have to move any of its assets into a different corporation or LLC. So it's pretty simple from that standpoint. But the main drawback is that the building, let's say the store, you're buying the building itself as well, and say it's got really crappy plumbing, or it's like in a flood zone that's going to like flood in the next possibility of flooding or something like that. Or somebody slipped and fell on the sidewalk in front of it and they're going to sue the store. It has liabilities with it because it's older, it's already existing, and it's been around. And you, as the new owner of that store, now you take all those liabilities, which, hopefully you will have discovered any liabilities before you decided to buy, but you may not have discovered everything. And so you take all of those potential liabilities with you when you buy the store. So also, stock purchases can have some unfavorable tax consequences, mostly for the seller, in that they can take, they'll typically, if you do a stock purchase, the seller usually realizes their profits from that sale as regular income rather than, and it's taxed at a higher rate than if they were to get it at a capital gains rate. And again, I'm not an accountant, so I talked to an accountant about this for each specific instance. But that's often another reason why people don't want to do a stock purchase, because it's there's less favorable tax treatment. There are some tax elections that you can make that can give you more favorable tax treatment. And Acquira, I know it's in their standard LOI. They probably talk to you about it. And those are options as well, but it's just something to think about. So let's say you don't want to buy the store itself. You want to build a brand new store next door with all new plumbing and lighting fixtures, everything, no hidden liabilities. And then you just want to buy all of the stuff in the old store and move it right next door, including the sign out front. You're just going to take the sign off the old store and put it on the new one. So for most people, they won't even notice that it's a different building, let's say, for the sake of this analogy. And then you take all of the good stuff from the old company and you leave all of the bad stuff. That's what happens in an asset purchase. So in an asset purchase, instead of buying the LLC or the corporation itself, buying the stock or the membership interest, you're buying all of the stuff that it owns. That includes all of its contracts. That includes its accounts receivable, also its accounts payable. It includes any of its inventory, if it has inventory or other tangible physical assets. If it has vehicles or other equipment, you're buying all of those things and you're moving them from one company to a different company that you just recently set up, a new LLC or a new corporation. So the pros are that you don't take any of the hidden liabilities of the old company. If in 2 years somebody comes to the old company and they say, hey, I was injured and or one of your products harmed me in some way, while the old company owned all the stuff, the old company is responsible for any liability that person brings against them. Let's say the old company didn't pay its taxes or something didn't pay enough in taxes 5 years ago, and now the IRS or the state tax entity comes knocking. The old company has to pay that, and the new company that has all of the assets is not obligated, or is not liable for those liabilities. So that's the main reason people like asset purchases, and they're very, very common. Also, you get more favorable tax treatment for both the seller and the buyer. The seller gets to realize the sale of the assets, usually as capital gains, taxed at a lower rate, and the buyer typically gets to take a new basis, or whatever the purchase, however much they paid for the assets, that's their tax basis in those assets, and then they can maybe depreciate after that or whatever. And that's, again, it kind of depends on the situation, but it's typically more favorable than a stock purchase. But the drawback is that you have to legally move all of the stuff from the old company into the new company. It's not a huge deal most of the time, and maybe the old company, maybe there's not a bunch of stuff, maybe it's mostly intangibles, but it can be a little bit more of a headache transferring title to vehicles or things like that. And the hardest thing, I think, to transfer in an asset purchase is our contracts. So let's say your company, or the target company, has a bunch of contracts with its customers that are ongoing contracts. Like you have a service contract where the target company provides certain services for its clients on a monthly basis or something like that. Those are incredibly valuable. They may be the sole assets of the company that you want, right? And but those contracts are all with third parties, and you can move those contracts from one company to another, but sometimes contracts have provisions in them that say, hey, you can't move this contract, you can't assign this contract to a new party without getting the consent of both parties to this contract. So you may have to contact each of the clients of the target company and be like, hey, I'm going to be the new, this new company's buying the assets, we're going to service this contract going forward, are you okay with that? And some contracts may say in there, like, these cannot be assigned, they cannot be moved to a different company. I typically see that with government contracts. Government contracts with their contractors, they usually say you can't assign these contracts to a different company. So a lot of times people will do a stock purchase because they want to maintain those contracts and they don't want to move them, or they can't move them. So that's kind of the biggest, in my mind, that's one of the biggest reasons to do a stock purchase. But you need to know this going up front. And a lot of times an LOI will say, you will do either a stock purchase or an asset purchase, but it's not quite been decided yet. That's the very first thing that we need to figure out when you're putting together your purchase agreement. Okay, so the next question I'm going to ask is, who is the buyer? So there are three options for what legal entity can be a buyer in this situation. One is you as an individual, a living, breathing human being, can buy the company, buy the target, either the stock or the assets, in your own name. So this is an option. It's not really an option for an asset purchase. If you're doing an asset deal, I would never recommend that you as an individual buy all of the assets of a company and hold them in your own personal name. That does not give you any protection from liability whatsoever, so I would never recommend that you do that. But if you're going to do a stock deal, then it's very common to have an individual be the person that's buying the stock. So you, Jane Doe, you're going to buy 100% of the stock or 100% of the membership interest in Acme, LLC or Acme Corporation, and you hold them in your own name. You still have a level of protection, a layer of protection, because you still own that corporation or LLC is still in place. And so you as an individual are still protected in that instance. And it also this can work as well if the target company in a stock purchase is an S Corp, which gets more favorable tax treatment than a C Corp. And we'll talk a little bit about that in a minute. S Corps have, there are restrictions on what kind of entities can own an S Corp, and individuals can own S Corps. And so if you want to maintain an S Corp election, you may want to just own the stock as an individual rather than through a different entity that may not be eligible to own an S Corp. So also, okay, so then that's kind of the individual option. An LLC is, I think, probably the best option for deals of the size that I see, between $1 and $10 million. LLCs are very easy to set up. They work well for stock purchases. And you just set up an LLC with the whatever state you're in and whatever state you want to incorporate in, and then it buys all of the stock of the company, or it buys all of the assets of the target company. Again, if the target has S Corp status and you want to maintain that, which I imagine you do, the LLC can only be owned by a single person. So it can only be a single member LLC. So that can depending on if you have a partner or whatever, a spouse that you guys are buying together, you have to do something a little bit different. LLCs are also great options for buying real property. Most commercial real property that I've seen is owned by an LLC, not usually a corporation. And so, but I want to talk to you about, hey, have you thought about how you want to do this? Maybe you already have an LLC set up or a corporation, or maybe you are going to, you just haven't decided which one yet, but we need to talk about that. And the third option is to set up a corporation to be the buyer. So the main reason that you would choose to do a corporation is that you, at some point in the future, want to transfer or sell shares of stock in your buyer corporation to somebody else, whether it's an investor or like a venture capital fund or something like that. It's very easy to transfer shares of a corporation, and whereas it's much more difficult to transfer membership interests in an LLC. So if you're buying this company and you're like, hey, I got big plans to expand or to bring in investors or whatever, then you probably want to set up a corporation as the buyer, because then it's easier to do all of that down the road. But kind of the drawbacks are, there's C Corps and there are S Corps, and C Corps get taxed. You as the owner of a C Corp essentially get taxed twice. The corporation itself has to pay taxes, federal taxes at least, and probably state taxes. And then you as the shareholder, on all the money you get from the corporation, you also have to pay taxes on that. So you get taxed twice on that. Whereas an S Corp is set up under a different part of the tax code, and it is a pass-through entity, meaning that the S Corp itself does not pay any corporate taxes, no taxes at the corporate level. And so it's like an LLC in that the taxes all get passed through to the shareholders. But as I briefly brought up, S Corps are limited in who can own them. They're limited to individuals, certain kinds of trusts and estates, and also LLCs that are single member LLCs. So you can't have a partnership on an S Corp. You can't have another corporation own an S Corp. You can't have a non-resident alien own an S Corp. So if you want any of those kinds of entities to be an owner in your buyer, then an S Corp is not going to work for you. And you can also, they're limited, you can only have 100 shareholders, and which, maybe you're like, oh, I'm only going to have one, but maybe you want to have 100, more than 100. And you can only have one class of stocks. You can't have preferred stock common stock in an S Corp. So a lot of things to think about. I'm throwing a lot at you right now. And so this is something that we would talk about in much more depth. And I would be like, what is your goal here? And we would go from there. So it's a lot to take in on one presentation, but this is a very important consideration for you as the buyer, for your tax treatment, for your future plans for the company, and how you want to run the company in the near term as well. So I would say that for most of the Acquira folks that I've worked with, LLCs work very well for asset purchases, and either individuals or single member LLCs work very well for stock purchases. And that's kind of what I advise my clients to do in these kinds of situations. Okay, so moving on, my next question for you is, and I haven't been checking the chat, so let me just check really quick and see if there's no questions yet. So okay, my third question is, who is the seller? So this is not quite as important as who is the buyer, as far as and you as the buyer have don't have any control over how the seller is already set up. But in a stock purchase, the seller is likely an individual who owns all the stock or membership interest in the company, or it's like a trust. Maybe somebody set up a living trust that they own all of their assets through, including their business. And so it's either an individual or a trust that's actually selling the target. The target is not the seller. The target is the thing that you're buying in this situation. And again, the question comes up, is the target an S corp, or is it an LLC taxed as an S corp? I failed to say this earlier. So LLCs are by default, if they have more than one member, LLCs are taxed as partnerships under the Internal Revenue Code. But an LLC, and that is a little bit more complicated for tax purposes. Partnerships are a little bit more complicated. And so I have an question here. Can an LLC be considered an S corp, or is that the same as an S corp? So an LLC can elect, make an election to be taxed as an S corp, and but it still must have the right types of owners. So if an LLC is owned by a corporation, it cannot choose to be taxed as an S corp. But an S corp, whether you have a corporation, something Inc., or whether you have something LLC, choosing to be taxed as an S corporation, in both instances, they have to follow the rules of who can own an S corp. So, and if you have that, if your target company has that S corp status, whether as a corporation or as an LLC, you probably want to maintain that. I don't think you would want to get rid of that because it saves you from paying double taxes. So you need to know that, though, to know how to set up your buyer. And that's like I say, mostly really only relevant in a stock purchase situation. In an asset purchase situation, the target itself is the seller. So you're buying all the assets of Acme, LLC. Then in the purchase agreement, it's going to say Acme LLC is selling all of the assets to buyer LLC. So it's a little bit different in the stock purchase. It will say, Jane Doe, who owns all of the stock of Acme LLC, is selling that stock to the buyer. So it's just a little bit nuanced and changes how we draft the purchase agreement and some of the kind of ancillary documents that go along with the purchase agreement. But we need to figure this out if we're going to move forward with that. So a little bit less complicated than who's the buyer. So let's see. So the question here is saying, my understanding of a single member LLC, the owner cannot take a salary. They must take income as distributions. So I'm not a CPA, so I'm not an expert on this, but my understanding is that a single member LLC can elect to be taxed as an S corp, in which case the owner would take a salary or wages and get a W-2. They could also take distributions, and those would be reflected on a different kind of tax form. But this is, the tax issues, I'm kind of flagging them here for you. And talking about any specific situation, I would be happy to talk to you offline, or talk to your accountant or your CPA about how it applies to your certain situation. Okay, so who is the seller? That's kind of, I think, all I had on that one. So fourth question I'm going to ask you is, Move my slide forward. Okay, we're gonna need to figure out the real property where the company operates. I know that Acquira, I think a lot of the companies that Acquira folks end up buying are kind of brick and mortar places, a lot of service companies that operate out of a certain specific space. And so they have a lease, or they own wherever they operate out of. I do a lot of deals too with kind of more maybe like an e-commerce company or something that doesn't necessarily have like an actual space. Maybe the owner's remote or whatever and just work online. But assuming that you have an actual office space, we need to figure out what you're gonna do with that. Or excuse me, if the target has an actual office space or a location where it operates out of, we need to talk about how you want to move forward with that. So there are two main situations that I see. So one is that the target, let's say you have a target Acme company, let's say Jane Doe owns it. She owns the business that runs there. That's Acme Incorporated, is the business itself. But she also owns the building / the land underneath it. And she probably doesn't own it through Acme LLC. She probably owns it through a separate entity, probably an LLC, Acme Real Property LLC. Commercial real estate is almost always held as a single asset of an LLC. I shouldn't say almost always, but very frequently held as the sole asset of an LLC, and that's for liability reasons. And so, she may own both the business and the real property in two separate entities. So I, recently had a client that this was the situation. The seller LLC was the target company. They were buying all of the stock in the company, and they were also going to they wanted to buy the real property underneath. It was also owned by the same principals of the target and of the real estate underneath. So they set up two LLCs, one to buy the business, the target LLC, and then one to buy the real property from the real property LLC. So there was kind of two entities that owned the business and the real property selling to a company that owned the business and the real property. And that's a great way to do it. If the seller wants to sell the land, wants to sell the real property along with the business, that's great. We do two separate purchase agreements in that situation. Real property, many of you may have bought a house or some other piece of real property and may be somewhat familiar with that process. There's some different mechanics that go along with selling real property versus selling pretty much everything else in the world, any other kind of property. But it's not too big of a deal. We just do two different purchase agreements and they close at the same time, and you walk in and you take over the company and you own the land underneath it. But what if the target principal, the person, or whoever owns the real property, they don't want to sell it? They're just like, hey, this is a good investment for me, or whatever reason. So if it's the target principal that owns it through a different entity, then you, as the buyer, once you close on the company and close on the target, you're going to have a lease. You're going to need to have a lease in place with the target principal who owns the real property underneath. And again, this isn't a huge deal. Commercial leases are not rocket science. They're drafted all the time and usually have pretty standard terms. But that's something that we need to figure out and start talking to the target principal about pretty early on. And the bank is going to want to know this too. The bank is kind of the tail that wags the dog in these kinds of situations. That's probably not an accurate analogy because they're much bigger than just the tail. But they're going to want you to have a lease in place. If you're not going to own the real property where the company operates, they're going to want you to have a lease in place for the term that is at least as long as the term of the loan that they're giving you. So if they're giving you a 10-year loan to buy this company, you have to have a lease in place that has a 10-year term, or at least like options to renew for at least 10 years. That's like an SBA requirement. So we need to talk about that with the seller if the seller principal is the landlord. Alternatively, and this is probably a little bit more common from what I've seen lately, is that the company operates out of a space that they've been leasing for however long, and it's just a completely different third-party landlord that owns the real property. And so if you are doing a stock purchase, then technically, you're just stepping in as the owner of the target, which is the party to the lease. So the parties to the lease are not actually changing in that situation, but you still want to talk to the landlord and say, hey, I'm coming in, I'm buying Acme Incorporated, and I'm going to run it. I know that Acme has a lease with you. You know, it's got 5 years left or whatever. I need to have at least another 5-year extension to meet the 10-year requirement of the bank, or whatever term it is. And you're also just going to want to let them know, because you're like, I'm going to be working with this landlord for however long. And chances are that in the lease that's already in place, it probably has a provision in it stating that if the ownership of the target company changes, then the landlord needs to be notified. And, you know, may say like they have to give their consent to, you know, the changes or whatever, which, you know, hopefully it says, which will not be unreasonably withheld. And this is typically not a big deal. Most landlords like to keep good tenants. And so if the target company has been a good tenant, the landlord's not going to be like, oh no, absolutely never going to allow this to happen there. But it may also open up an opportunity for the landlord to be like, oh, hey, well, now that you're coming to me and you need something, we're going to renegotiate these terms. That could happen as well, but there's just kind of no way around it. You need to really be upfront with the landlord in those situations. And, you know, they may want, or they may not be interested in, or they may want an entirely new lease. Which again, it's not a huge deal, but it just kind of depends on what is negotiated and what the landlord, kind of how easy or difficult they are to work with. But these are important questions that the bank is going to want to know, and that you need to know, and the landlord needs to know going forward. So we're going to talk about that. Sometimes leases are attached as exhibits to a purchase agreement, especially if it's a new lease. And that's a very normal thing. That will have a clause in there. The bank will probably make the landlord sign something saying that you as the borrower, if you have to choose between paying the bank and paying your landlord, you have to pay the landlord, or excuse me, pay the bank. The landlord may not like that. Anyway, it just kind of goes, it kind of depends on the situation. Okay, so moving on to question number 5. So what about financing? How are you coming up with the money to buy this business? Now, you may have enough capital that, you know, at your disposal to pay cash for the company. And if you do, that's great, good for you. That simplifies things and speeds up the process considerably, because the bank is the slowest moving part of this whole process, and also they have the most requirements and everything. So if you don't have to deal with the bank, that's great. You'll be able to get this done relatively quickly. But we live in a world where people finance things like this. So typically, the financing is a combination of a bank, which is providing most of the funds, and then the seller is probably going to provide some kind of seller financing. If it's an SBA loan, they're going to require like 10% of the seller to finance about 10% of the purchase price. And then the buyer's probably got to come up with some kind of cash up front, either as a deposit or equity injection at closing. So it's a combination, the bank by far being the largest portion of the purchase price. So seller financing is Acquira has it in all of its standard LOIs that the seller will finance a portion of the purchase price. Like I said, usually about 10%. And that's not like too big of a deal. A lot of sellers I kind of understand that they need to do that to meet the bank and the SBA's requirements. But I do want to talk about the security, whether or not the seller loan is secured. So I've mostly represented lenders in my career, and when it comes to finance stuff like this, and I would never, ever, ever tell a lender to give an unsecured loan. I would never do that. You wouldn't want to lend hundreds of thousands or millions of dollars to somebody without taking some kind of collateral to secure your loan. That being said, sometimes, or a lot of times, LOIs that I see will say, hey, the seller's going to finance some portion of the purchase price, but it doesn't say whether the loan is going to be secured or not. So as the buyer / borrower's attorney, I'll draft up the promissory note, and I won't put a security section in it. I'm not gonna, I'm not gonna give in the first instance, say to them like, hey, you want to take a security interest? If they're not smart enough to know they need to. They probably are. They should be smart enough to know they need to do that. And if the seller doesn't know that, then their attorney should be smart enough to know that. So they'll probably come back and say, hey, we need to secure this in some way. But I have found that a lot of times the parties themselves haven't really thought about this part of the seller financing. And so I like to talk to my clients about it up front and be like, hey, you says here the seller's going to loan you $400,000 as part of the purchase to, finance. They're probably going to want some security for this. I'm not going to put it in the first instance unless you want me to. But, have you and the seller talked about securing the loan or whatever? And a lot of times my clients will say, no, we haven't talked about it yet. And that's totally fine. That's what I'm here for, right? Is to bring this up to your attention. But and I have seen deals where the seller gave an unsecured loan, which I was astonished, but it's great for my client. And there's nothing wrong with that. It's nothing unethical, or what, they just didn't know that they didn't, for whatever reason, chose not to do that. But there are two main types of security interest for a loan like this. So the first is taking a security interest in the things that are in whatever is being sold, whether it's the stock in the target company or whether it's the assets that are being sold. The seller, there will be a section in the note that says the seller has a security interest in the stock or in the assets. And what that means is that if you as the buyer, or as the buyer entity at some point fails to pay its loan, then the seller can come and foreclose on either the stock and take the company back, or all of the assets, take it back into their old company and run it again if they want, or sell it off and use that to satisfy the loan proceeds that they have not yet been paid. So that's, obviously not good for you as the buyer. If you're not making your loan payments, you're already having struggles. This is not going to come as a surprise to you. But that's one type of security. The other is a personal guarantee. And what a personal guarantee is it's the lender saying, hey, I'm lending money to Buyer LLC. I know that Buyer LLC is an entity. It's like a legal entity. It may have assets, but maybe the owner of Buyer LLC is going to drain all the assets out of it or something to that effect. Or maybe Buyer LLC is going to go, not through any fraud or anything like that, but just because business is bad, it's going to go out of business, lose all of its assets, but I'm still owed a whole bunch of money by Buyer LLC. So I'm going to then, a personal guarantee is when the owner of Buyer LLC, who is probably a natural person, says, hey, I promise that if Buyer LLC doesn't pay its loan, I will pay its loan on its behalf. And it allows the seller or the lender to kind of bypass Buyer LLC and just come straight to the real person who presumably has some assets and also doesn't want to be in debt for the rest of forever. And so they're going to, pay off the loan on behalf of the Buyer LLC or Buyer Corporation. And so their bank that's financing is going to require you to give both of these kinds of security to them. And they're going to require that they get first priority. They're going to be like, hey, if something goes wrong, you don't pay our loan, we get to come and foreclose on all your stuff. And also you, human being, have to pay the business's debts. And we're the first in line. The seller is probably also going to want those two types of security. Sometimes you can get away with only giving one of them. And I've had some clients that have very strong feelings about one or the other. They either absolutely did not want to give a security interest in the purchased assets, or they did not want to give a personal guarantee, but they didn't care about the other one. They're like, oh, whatever. And then I've had many clients who were just like, oh, great, they can have both. They can get in line behind the bank, right? If something goes, if the company tanks, they can get in line with all of my other creditors. But I like to talk to my clients about this up front, because a lot of times they haven't thought about it, and it's something that they need to think about and figure out how they feel about it. I personally don't think that if you can get away without giving a security interest, good for you. But it's not something, in my opinion, that's worth fighting with the buyer, or with the seller about, because it's really common and it's really market to give a security interest. So, okay, last question. I know we're getting close to time here. So I'm going to want to talk to you about net working capital. In my experience, net working capital is one of the most hotly negotiated, contested parts of the purchase agreement. So Most LOIs that I see do not really address net working capital in detail. Though a lot of times will say, hey, the parties will discuss net working capital in detail and include the details of their agreement on it in the purchase agreement. So it's been kind of kicked down the road, this discussion, until we get to the purchase agreement section point of the process. So, but first to kind of talk about like what is net working capital. Essentially, it's just cash or cash equivalents or a combination of the two that you use to run your business, to run the business post-closing. So you walk in the first day, the day of closing, the first day you own the business, and next week is payroll. And then also the week after that, you have a bunch of bills from your vendors that you need to pay. You need cash to run any kind of business. And so, you need cash on day one, really. And so there are kind of two ways to get this cash, two main ways that I see people do it. And one is that the seller, either if you're doing a stock deal, they'll leave a certain amount of cash in the operating accounts of the target business, or if it's an asset purchase, part of the assets that you buy is some amount of cash that they will just that the seller will just transfer from its bank accounts into your buyer's bank accounts. But it doesn't have to be cash. It can be accounts receivable. It can be inventory. Anything that has like a fixed kind of value that you can liquidate easily. And if you have a company that has its accounts receivable are collected like really quickly, short term of payment from its customers, or maybe immediate payment from its customers, then AR is almost as good as cash. And so you can take that if the seller doesn't want to leave a bunch of cash. But the point is that you need to have liquidity to run the business right after closing. And the bank is also probably going to require this. They're going to be like, hey, I'm not going to lend you a bunch of money to buy a business, and then you fail in the first 2 weeks because you didn't have any money to pay what you needed to pay your employees, and they all quit. So the other way that you can get the kind of the con of having the seller provide the net working capital is you have to negotiate it with the seller. And a lot of sellers are just like, the idea of giving the buyer any cash is just, they don't like that idea. If or maybe they don't have a lot of cash on hand and they run a really lean ship or something, and they don't have enough cash to leave behind. So there's another way you can do it, and that's to get a line of credit from your bank. And that's really simple. I mean, it doesn't involve any negotiation with the seller. And it's, so from a practical standpoint, if the bank is willing to lend you, then that's great. The downside to that is that it's a loan and you have to pay interest on it. But in reality, if you're getting net working capital from the seller, they're not just giving you money, they're lending you $200,000 and then increasing the price of the company by $200,000, which is then being paid by the bank. And so you're essentially, it's almost like a loan anyway, and you're already paying interest on that. But it kind of just depends on the situation and what the bank requires. But that is something that if it has not been discussed with the seller yet, you need to start talking about it and figuring out how much cash you need to run the company. You'll figure that out from their financial statements, looking at the history of how their cash flow works, talking to your accountant or financial advisors about it, and also figuring out what the bank requirements are, and ultimately what the seller is willing to agree to.
Hey,
that's a lot.
Could I throw in a thought on that? This is Dana Bickford.
Sure.
Could I throw in a quick thought on that?
Yeah, we have 4 minutes. I want to leave some time for questions.
You're essentially, if you're paying them for the company and paying them for the net working capital, you're paying them twice for part of the company. Yeah. So you're making a good point there. Thank you.
Yep. Okay, so I wanted to leave some time for any questions that folks might have, anything that I can answer for you in the last few minutes here. And if no questions, that's great, but wanted to leave some time for that.
I have a question, John.
Yeah, absolutely.
Have you dealt with 338H10 deals that make an asset purchase look more like a stock purchase look more like an asset purchase?
Yes, so that is one of the main elections that folks will use in a stock deal to make it. It's an election that you make, and therefore where you assign a certain value to the different assets of the company, its goodwill, its inventory, whatever other types of assets it has, and you assign a portion of the purchase price to those types of assets, and then you file it with the IRS, and the IRS then treats the stock deal as if it were an asset deal, even though it's not. And then it allows for the more favorable tax treatment for both the seller and the buyer in that instance. So that is one way. That's one election. The other is a 336E election. And which one you can take depends on whether the buyer and the seller are corporations or LLCs and what their ownership structure is, because each election has its own specific requirements for who the parties have to be. But that's definitely something, and Acquira puts that in a lot of its standard LOIs, that the parties agree to do that to get a more favorable tax treatment for an asset, for a stock purchase.
I thought the 338H10 was generally more advantageous to the buyer. They can step their assets up to current market value. But the seller, I thought it was harder quite often to persuade the seller to do it.
I've seen in some instances where the seller was really driving it, where they're like, I want to get, and I think it kind of depends on the business and depends on the parties and what their accountants think is better. But you do have to come to an agreement on how to allocate the purchase price, because both the seller and the buyer have to file documents with the IRS with the exact same allocation.
Yeah.
And so you have to come to an agreement on it. One can't assign 80% of the purchase price to goodwill and the other assign 80% to inventory. It doesn't work that way. You have to agree on that. Okay, another question, Richard Hendy, go ahead. Richard, you're muted. Sorry, we still can't hear you, Richard. You're muted.
Hey, Dick, I think you're muted. Can you hear us?
Yeah, how about now?
Oh, there.
I can hear
There
you
you
now.
go.
Yeah, John, I want to applaud you, give a lot of great advice here, and I would recommend all the people that are on the call that are looking at buying a business. I know writing in a check to an attorney to give them advice on looking at all this stuff is something that they may not want to do because they want to preserve their cash, but it's really difficult, as you know, to unwind one of these things once some documents have been signed that haven't been looked at.
Right.
So I would encourage you, before you sign anything with anybody on a purchase deal, that you really get the proper people involved, because it's going to save you a lot of aggravation and a lot of money down the road. So I applaud you, John, for everything you've done here.
Thank you. Yeah, I second that. I appreciate the plug. Thank you. Elnada, did I say your name right?
Yes, thank you so much, John. I have a question.
Yeah.
So we're doing we're in the process of acquiring two companies. They're the same kind of company, and our intention is to merge the company into one company. I don't know if that's the best thing. They're the exact same kind of company. I don't know if that's the best thing to do or to keep them separate, and I wanted to see what your thoughts behind that.
So it really depends on, sorry, I'm in a very lawyerly response here. It depends. So I would know, why are they separate in the first place? Were they owned by different people and you're just acquiring two totally separate companies and wanting to bring them together?
Yes, absolutely.
Okay.
Yes,
I think that one danger, the biggest danger of doing that is that if you merge the two companies, then presumably you're gathering a larger pool of assets, a larger company that owns more stuff. And anybody who has a claim against one of the former companies, if you're doing a stock deal, they may be able to come after the new entity that owns all the stuff of both companies, and they have more stuff to get to satisfy liability or their claim. So that's a danger. If you're doing an asset purchase, there's less danger of that, right? Because you're not taking the liabilities. But I would also want to know what you were hoping to accomplish by combining the two. Maybe it's administrative or tax, simplicity or something like that. But It would really just depend on what your situation is and what your end goal is, and doing that as that would change my my answer to what.
Well, we wanted to merge them, one, because they're basically in the same area. They're just two different companies ran by two different people, right? They have separate real estate. But the other thing was to bring them all under the same system, which we can still do if we keep them separate. But we were just thinking like, oh, we'll just merge it because but we were going to separate the human resource department. Like we were going to create a separate entity for the human resource department and just merge the assets and the contracts that they both run under, which is two different, because they're two different companies. They have two different MSAs.
Yeah. It would, to give you more detailed advice that I'd need to know more about the situation, but I think that it's certainly something you could do. If that's what you wanted to do, there's a way to make it work. So.
All right. Thank you.
Yeah. And I wanted to put my contact information up here, and I know that Andy's going to send it out. I'm happy to have just like a free 15-minute consult with any of you. Please just contact me and we'll set up a time to talk, to chat. Just some free advice. Happy to answer any questions that you might have. Any other questions right now on the chat? I know we're over time and I want to be respectful of people's time. Okay. Andy, it seems like that's the end. And so, yeah, just love to hear from any of you. Please feel free to reach out. And I believe Andy's going to send this out, and hope to talk to you soon. Thank you so much for having me. It was a pleasure to speak to you all.
Well, thank you so much, John, for sharing your expertise. I'll definitely share your contact information to everyone.
Great.
And yeah, see you on the next call. Thanks again, John.
Thank you. Have a great day, everyone.